Welcome back to Open Line, talking with Tim Takis, elder law attorney. And we were talking about wills. Sandy called in with a question about wills.
Right.
And we were on the point, you don't leave someone just $1 because that gives them standing.
Right.
Standing, it means a lot.
Standing is a legal term for that you have a right to be heard, that your views have a right to be taken into account, in whatever form that you're in. In this case, it would be probate court. And if you're a beneficiary of an estate, whether you've been left $1 or $1 million, then you have certain rights as a beneficiary. You have a right to notice of the proceedings. You have a right to to ask for an accounting. You have a right to ask for an inventory. You have a right to kind of go into the judge and say, Your Honor, even though I'm only going to get $1, I want certain things to happen. And I know of no law that says that the court has a right to look at, well, you're just a little player over here.
Right, right.
I know no knowledge about any law that says that, that we're going to look at a dollar amount first to see whether you're really, entitled to all of these rights. The judges just say, okay. And that's why we tell people, we say, don't do the, I'm going to leave these people $1.
Which I've heard for many, many years, so that's always very interesting to me that you say that. And then the notion that your spouse is always entitled. You can't disinherit your spouse unless he or she consents.
Or he or she agrees.
yes.
Exactly, yeah. Now, how do they consent? One way they consent is if they have a premarital or prenuptial agreement.
Okay.
So so a lot of times married couples, particularly ones who were older in life, maybe subsequent marriages, we would suggest that, that they do, have those. And it's kind of interesting. I've done probably a handful of those at the most. Most of the time I send those to like someone that does more domestic relations work than I do. But I also tell people, I'll say, one of the things that you have to think about if you're getting married late in life, okay, you're 70-some, and both of you have been married, maybe divorced, or, both of you are widowed, so you meet these people and you go, boy, I didn't expect this to happen. So here you are, you're 80 years old, each of you, and you get married, and then you start thinking about, well, what about children and grandchildren, and you bring an inheritance, maybe one of you does or the other one does not. I've had that happen before. I've had a married couple. I had this one gentleman walk in and say, well, we've been married for 7 years, and in our 3rd year of marriage, my wife gave away all of her money and property to her children, and then 2 years later, she developed Alzheimer's disease. And I said, well, I'm sorry to hear that. So it's basically, well, he still has an obligation of support.
Wow. And that comes down to another issue that we talk about. Should people want to start gifting money away to their kids?
Yeah.
And I guess there's a way to do that that's appropriate, but sometimes they can go way too far.
They can go way too far. It's like, okay, so what is way too far? One is that if you give, if you give something away, if you give it away outright, in other words, no strings attached, other than that, Ben, I'm gonna give you my house. And you're going to promise me that I can live there for the rest of my life, right? And Ben goes, yeah, right, Daddy. Until something bad happens to Ben, because parents don't ever think about that.
Ben would mean that you could stay there forever.
Right.
Like, I think when that's done, I think, the child generally believes, okay, sure, they give it to me and I'll take care of it. And Mom, Dad can stay there as long as they want. Sure,
that's as long as, okay, you own that house, but my example is, okay, Ben rides down the road and hits a bus full of school children. He says, and they said, well, you got this house, and you're not living at that because you're living over here in this other house, and you're going, well, no, you can't touch that house because my mom and dad living in there, and I promised them, that they could live there for the rest of their life, and it's like, well, so what are you going to do about those the parents of those school children? You think that's right?
Mm-hmm. So the child gets in trouble,
right? And
then because the house or whatever has been gifted to the child, it can all be lost.
It can be lost, right? And then what you get, and sometimes I tell people, I say, okay, who are the most unreliable people on the planet, right? And that's children, because children will say, oh yeah, Mom, I'll hold that for you. But then the child gets, into a fix, or the child's daughter or or grandchild. Okay, so you got the 60-year-old who's sitting there on $100,000 that she promised, to hold for mom in case mom needs it. Well, now daughter's 21-year-old granddaughter, has got some sort of serious illness, and she goes, well, I know mom would let me use that money for her great-granddaughter. Mm-hmm. I mean, there's all sorts of excuses or justifications.
And even a divorce.
Yeah.
A divorce,
right.
The property is divided.
Exactly.
As we've talked about.
Exactly. And it's not, you can't always count on the fact that, okay, mom gives you, I give Ben $100,000, and then you share it, with, so you put it in your wife's name just so that, she can write checks out of it in case, in case you're like out of town or something happens to you. Well, now suddenly you've commingled that property. It becomes marital property.
So what is a good reason, and I know that people do it, what is a good reason that people gift money or start giving large amounts of money? Or do you think there's not really ever a good reason?
Well, that there is, and I remember one of my colleagues a few years ago and, talked about, okay, what are good reasons why people give money to others? One is that you want them to do something. I'll give you $100,000 if you'll go to law school. Or I'll give you $100,000 if you won't go to law school, but buy a house instead. I mean, or to do something or not do something. Mm-hmm. That's or because you want somebody to have it. Or you want it to put it out of reach of your creditors or your potential creditors, and sometimes that's fraudulent, or sometimes it's not.
Wow! So you could do that. You could give it. Well, that's interesting.
And not that you want to. Now, not that you want to do something fraudulent, but you can. Some people go. Let's say if you're in a fairly high risk business, it's like, well, I'll give my house to my kids because, I'm in some sort of high risk occupation that. I need to make sure I don't own it.
Right,
but I might have, but my kids might let me live in it. And those sorts of things. So you have all sorts of things like that. But for people to give money or property away with the expectation, that it's going to be available to them in the future, that can be a problem.
That can be very dangerous.
Very dangerous.
So, all right, something we talked, trusts. Mm-hmm. Let's get into what trusts are.
Right.
We usually get calls about that, and I would encourage people to call in. What are trusts? How do we use those things?
Okay, a trust is a legal way of owning money or an asset. It can be money, it could be cash, it could be real estate, but it is an asset of some sort. It's a legal way of owning that. And sometimes, I'm going to grab this here, and here we go. And we have, so think about this as I'm holding this, and then you, so now you put money, into this bucket, and that's a trust. And the person that's holding that is me. I'm the trustee. Okay, and you tell me, as a part of my instructions when we set up this agreement, you say, okay, now Tim, you can take this out and you can use it over here, but you can't use it for this over there. So you put limitations or stipulations on how you can use the trust assets. Okay, so and it could be me as the I might be, and that person is called the beneficiary. All right, and the idea is that there's a legal relationship that you and I have where I've agreed to accept this asset and use it in a way that I'm supposed to for the benefit. And it maybe there's money in here, and I'm the big brother, and mom and dad have given me money so that I can use the money in this for my younger brother who has a disability or incapacity.
That's one of the biggest, right? Is for a parent, they have a child who is disabled, they're worried they're going to die one day, and they want that disabled child to have money to live on.
Right, but they want somebody, if you give that money, or you say, if you just give it to the brother, the older brother, and say, here, hold this for your younger brother. Now that may work or it may not, until the older brother, he has creditor problems. And when you think about, I mean, I sometimes think about a trust as one of the great products of the human mind, because it's a legal construct that allows people basically from beyond the grave, mom and dad, to have some confidence, that the older brother has legal duties to his brother, to his his disabled brother. That's what they get. And if the older brother, the trustee, doesn't do what he's supposed to do, then sometimes if he does really bad, it could be a felony.
Right.
It could be a crime. If he steals the money from his younger brother.
If he's using it to go vacation, that's inappropriate.
Exactly.
But he has to use it in these ways that are written out.
And if you do it the right way, the older brother is going, okay, mom and dad made me the trustee for my younger brother. I don't think I can do that. So what maybe mom and dad in their trust document have said, well, this not involuntary servitude, being a trustee for your younger brother. So if you can't do that anymore, you can always resign, and then somebody else will step in, and maybe they name that person, in their trust. Or maybe they've clothed their son, their oldest son, with authority to name another trustee, to say, well, we realize that we don't want to put you in charge of your brother for the rest of your life, but just name somebody that will step in and be the trustee for him. That's all we're asking you to do.
So when it comes to trust, what's the big mistake, or a big mistake, or the biggest mistake that people make?
I would say probably not even having one at all.
Yeah, just not even thinking about it.
Not even thinking about it. And the most common thing that I think of is, obviously, parents are thinking about their special needs child, but they don't think about their special needs spouse. Your husband's been diagnosed with Alzheimer's disease, and so you're thinking, well, what are my options? Well, set up a trust for him. If you predecease him, don't assume that he's going to die before you do.
Right.
You have to. That's called planning. If you assume that he's going to die before you do, that's not planning. That's called hoping. And let's have hope, but hoping doesn't take the place of having a plan. So you set something up where it says, okay, if I predecease my husband, I want to make sure he's taken care of. We know that he can't manage the money or property, and if he's in a nursing home, it's all going to be gone. But if we set it as, if I die before he does and everything goes into a trust for him, I know it's going to be used for his benefit. And if the trust is done the right way, I know he'll be able to qualify for some public benefits to pay for his care. And because the law provides for that. And those are the kind of things that I think those are the mistakes that people, a lot of those mistakes are not mistakes of commission, it's mistakes of not even thinking about it. That they have that option, and they do.
Yeah, now that is really, and you don't have to get a family member to be the person, right? It could be a lawyer. I mean, so let's say you have a spouse you're worried about, and you don't want to maybe burden your kids don't want to do it. You could
You can name somebody to do that. Now, we don't do that because we'd have like a conflict of doing that document as well as being the trustee.
Okay.
But we will have people that will come in and ask us about that, and we'll say, well, let's talk about the identity of the trustee. And that's often the hardest thing for our clients to do, is to identify, who the right trustee is. Sorry, I got your. You
got my pen.
I will. That's a revocable trust right there.
Good.
Because when you got it back, that's called revocable. If I said to you, Ben, you can't have that back, that's a irrevocable trust.
Okay. See, we're learning. That's great. All right. Let's go to Milton. Hello, okay. Milton.
Yes, I'd like to ask 2 questions, but let me tell you about the first one. I have a sister who married a guy 25 years ago, and the guy had a son and a daughter. To show you about this first family, the son is now in prison. The daughter is an MD. She's a doctor.
Yeah.
Wow.
Okay. The husband died, and he had a house that my sister lived with him, and they were married. They had 2 children. One of them died, but the daughter's still living, but she's like late 20s now. Mm-hmm. Okay, here's the situation. He didn't do a will, and he owned the house before they got married.
Right.
The MD had said she wants nothing to do with the house. The wife can have it because she stayed with her brother, married to her brother for 25 years. But the brother that's in prison, he said, "Oh no, wait just a minute.
Right.
I want my portion of that house." And I'm saying, look, you were married to him for 25 years. I think you should have some right to the total house. But she hasn't checked with an attorney yet to see if that's the case.
Yeah, see, she would be entitled to a homestead. She has some protections there, as the surviving spouse.
Okay.
She has a right to a year's support. She has a right to homestead. There's some laws that protect the surviving spouse, over and above that pertain to the homestead. But I mean, clearly, it's one where, the surviving, I guess, is his sister, Milton's sister.
Right.
Who married this gentleman who died. It's clear that she needs to see a lawyer and talk about what her rights are, because obviously the guy in prison, he is I guess he's an heir at law. He's the son of the, and this man died. He did not have a will. The house was apparently just solely in his name.
Right.
So it's kind of like that situation that we talked about is that the spouse gets something, but then his children are entitled, as well. And apparently they had 2 children together, and then apparently he had 2 other children. So now there's 4 children and a spouse, and the MD goes, she's willing to basically say, I don't want it. Which is its own set of issues there, but then her brother goes, no, I'm in prison and I want this.
Right. Yeah, I mean, you can.
So that's the way it works.
All right, does that answer your question, Milton?
Yeah, so this first son does have some rights. Even though he's in prison, he does have some rights to the house.
Right, unless he killed him. Unless he killed his father, I think then he might not have any rights, but he's just, a lot of people are in prison and they don't lose their right to inherit.
Right. Yeah, people might think that, but that's not the case.
Right, but that's not the case, yeah.
Okay, we're going to take a break. If you want to call, there's the number, 615-737-PLUS, 615-737-7587. We'll take a break. Be back right after this.